Greetings, this is Chapter 10, Sexual Orientation and Gender Identity Discrimination. It's with great news that we know Title VII has now been interpreted as protecting LGBTQIA individuals, anybody who is considered a quote-unquote sexual minority. And this was a very revolutionary ruling, particularly by a relatively conservative Supreme Court. And so this is good news with respect to where the employment protections are coming from. Obviously, it would be better to have it more fine-tuned, but as we speak, it's great to know that the Supreme Court rules that being LGBTQI is protected under Title VII. There are 8 learning objectives to this chapter. Number 1, we're going to talk about the history of the modern gay rights movement and what that trajectory has looked like, how it influences the legislation. Number 2, discuss the state of LGBTQ workplace protections before Bostock versus Clayton County, Georgia case. And so what was like before and what it's like now with this new ruling. We're going to understand the significance of employers being inclusive of LGBTQ employees. We're going to discuss how some courts have circumvented the exclusion of LGBTQ employees from Title VII coverage. Number 5, we're going to identify whether same-gender sexual harassment is covered under Title VII, which it is. Just because a male is harassing a male doesn't mean that it doesn't, and this was even before the Bostock ruling, same-sex sexual harassment is definitely considered a thing. We'll talk about the context within which that occurs. We're going to discuss the workplace issues involving transgender individuals, some of the issues and concerns that are unique to being transgender, specifically around bathroom-related issues. We want to identify some of the employment benefit issues for LGBTQ employees, and we're also, lastly, going to list some ways that employers can address LGBTQ issues in the workplace. So this chapter is really trying to fine-tune that aspect of Title VII that specifically addresses the sexual orientation and gender identity issues. There's a tremendous way to go, but this is a huge victory for civil rights for the LGBTQI community. In terms of the statutory basis, it's the same as that for sex discrimination, specifically Title VII, talking about failure to or refuse to hire or discharge any individual, et cetera, because of sex or gender. And now, because of Bostock, we recognize that subset of sex discrimination also includes sexual orientation and gender identity. We also have the 14th Amendment of the Constitution, which is the Equal Protection Clause, says that nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So what that means is that male or female both should be protected, gay or straight should be protected, white or minority group should be protected. And the point behind this is that it used to be interpreted as, all males, white males, were property owners, right? And in terms of protections under the Constitution, and the 14th Amendment really tried to get at that all citizens should be equally protected under the law, that no citizen is more or less deserving of those protections and those rights. The case. This is the single most important case in LGBT history, Bostock versus Clayton County, Georgia. And the argument here is an employer violates Title VII when it intentionally fires an individual based in part on sex, because discrimination on the basis of homosexuality or transgender status requires an employer to intentionally treat individual employees differently because of their sex. And an employer who intentionally penalizes an employee for being homosexual or transgender also violates Title VII. And they came to this largely with the argument that when a woman loves a woman, or a man loves a man, or someone is transgender, it transgresses the norm of society, which presumes heteronormativity, um, that a um, man and a woman would be together and that there's no other variation on that that would be allowed, that you are the sex that you were born and you should be that when you die, when in fact we know that that's not true. There is biological basis for homosexuality. There are biological basis for being transgender. We know that this is not just about um, you know, choices necessarily on people's parts. And so when we recognize that there's aspects to homosexuality that are like handedness, like left-handedness versus right-handedness, where we know that an individual who is right-handed just knows that they are. There's no genetic code that you press a button and somehow you can change someone to be right-handed to left-handed. So what we're talking about is epigenetics, really, which is different markers that are on our genome that get triggered or get activated, if you will, and which creates where people's attractions are. It creates your left-handedness versus right-handedness. It's reflective of all sorts of different types of genetic issues kind of going on. So the Bostock case was really phenomenal in that we had a conservative court that basically argued that being homosexual or being transgender a was definitely considered a transgression of sex norms of what is to be female, what is to be male. That's largely how the argument was made. In terms of what it means to be in or out of the closet, right? About 4.5% of the U.S. workforce does identify as LGBTQ, and they suspect that it's more than that, but these are the ones that are more willing to publicly proclaim that they are gay, lesbian, bi, transgender, or queer, or questioning. Also, is the Q is used interchangeably, but most of the time people consider it as Q as queer. And 88% of those individuals are employed. So this has a huge impact on workplaces. The social bias, the workplace bias against LGBTQ individuals has created a lot of challenges, and it encourages and requires people to stay in the closet, meaning that they pretend who they are outside of the closet, but in the closet that they can be themselves. And that closet, as we know, has horrible um, has a horrible impact on mental health, on physical well-being, on emotional well-being. Um, and it can be a distraction in the workplace when someone has to continually pretend to check the pronouns that they use when they talk about their spouses or their significant others. It creates a massive problem for people, and people have lower performance when they're constantly monitoring and looking over their shoulder to make sure that they are not expressing who they are in the workplace. Whereas straight families can or families with straight parents, right? They can put displays of their photos of their spouses and their children on their desktop. For LGBTQ individuals, this is not allowed. This is not comfortable for them because that opens up the door for people to know who their significant other is and when they are being forced to hide it. So the social implications of this, the workplace implications of having to be in the closet is really difficult and challenging, and it is important for us to recognize that the damage this does to somebody psychologically, emotionally, needs to be managed. So this is why this case is so tremendous, because no longer do people have to hide in the workplace because they have protections. The gay rights movement is influential um, uh, in a relatively brief time. I mean, when you think about the trajectory from the Stonewall riots in the late 60s to now, the fact that we've almost come to the place where most people in the United States, certainly well over 50%, are completely comfortable with the idea of people having equal rights in the workplace, and not having discrimination out there. So the challenge, of course, is the very vocal minority that have religious concerns with LGBT individuals and then are trying to impose that in the workplace. And again, as we talked about religious discrimination and sort of the boundary conditions around religious discrimination, which is in our next chapter, you'll see that really, your religious rights are yours to practice on your own, and you don't have to impose those on workplace issues. So, definitely interesting. We're seeing much more of a national consensus, little by little. It's still elusive, but we're getting closer. And we have a president now that I believe will support that. Non-obviousness of sexual complexity and centrality um, is is key, right? It's sexual complexity and centrality assumes um, that people are heteronormative, that they are heterosexual. That's the assumption. That's the default, and it is complex. That it's not. There's not an on-off switch. It's a continuum of interests and beliefs and attractions and same thing with gender identity. It's also a continuum, around these issues. And so, and this obviously this course is not a lesson on LGBT rights and LGBT issues, but specifically the legal implications. But it is important to recognize that these things are not simple. They're not black and white, very straightforward. And as we talked about, right, the religious hostility that comes from people who are in religions that believe being gay is a sin, um, and also people's privacy rights. That what I do in my bedroom is none of your business, and who I choose to partner and have as my life partner is not anybody else's business. It's my right to marry. It's my right to choose who I choose to have an adult consensual, romantic, and sexual relationship with, and it is not the right of other people to interfere with that ability to do that. Before the Bostock decision, the laws were really all over the place. There's a lot of public sector executive orders. There were also some private sector laws, to some extent federal, state, and local, but the executive orders, company policies, they were really inconsistent across the United States, where you could be protected in one state, and if you moved to another, you could lose your benefits, right? Because the company would go by the state laws and the state rules and the state regulations. So in one location, um, you could be protected, but in another location you would not be. And some local laws protect, and you go across the street into a different county, and those local laws would not be adhered to. So, and speaking as someone who is LGBT, as a out lesbian, I had to make some really difficult choices as I was looking for work. The state of Virginia at the time when I was looking for jobs did not protect LGBTQI employees, and I had to choose to not apply for a position because of being an out lesbian. And I reached out to the school that was trying to recruit me, and I said, I would love to work there. I'm sure your university is wonderful, but I'm an out lesbian, and living in your state would not protect me or my family, and I'm not going to put my family at risk because of that. And they understood. They said, we understand, and we recognize that this is a problem, but unfortunately, our hands are tied where we're at. Like, yep, it sure is. So these are issues. I mean, when we exclude people, regardless of whether it's based on sexual orientation or race or sex or anything else, fundamentally, when we exclude a part of our recruitment pool and say, well, we're not going to hire you because you are a different color or you engage in a sexual relationship with someone that I don't approve of, you're limiting yourself from people who could be actual wonderful, productive members of your organization. You're shrinking your selection pool, and it means you're less likely to have a successful workforce and to be at the highest possible level that you could be, simply because you're excluding people who um, you know have no control over who they love and who they're attracted to. So, and the same thing with race, and as I said, and excluding women as opposed to men, right? I mean, regardless of sexual orientation, when you limit your pool, you limit your ability to be competitive. Period. That's what it comes down to, and that's the thing we have to hold on to as we think about diversity management. When you limit your selection pool, you limit the ability of your company to be successful, period. What are some of the landmark cases? Well, Stonewalls were big in '69. The Stonewall riots were largely led by minority transgender women who fought back when the Stonewall bar in Greenwich Village in New York was raided, and it was a riot. I mean, people fought and hard um, and were fighting back against the police, and it took that riot for people to say, you know what, you're treating us inhumanely, you're raiding our locations, you're throwing us in jail because we transgress the way you think we should be behaving. I said, and this is not okay. So what we started to see after that was people starting to come out, people starting to claim who they were. There were plenty of people still in the closet. I mean, nobody knew Rock Hudson was gay in the general public, and for decades until he died of AIDS. But as we started to see more and more people in the public claim their identity, it became safer for people. And I'll be perfectly honest. I didn't come out till I was 40 years old, largely because there were no role models when I was young, and it was easier for me to just pretend and ignore the fact what I felt and what my attractions were than it was for me to come out. It was just easier to stay in the closet, and I will tell you how difficult that was to constantly live with a stomach ache and constantly have to ignore, what I'm feeling and why, and not being able to identify and really look at why I was feeling or not feeling what I was supposed to be feeling. So it's pretty challenging. In terms of the Gay Pride Month, June is considered Gay Pride Month because that's when the riots occurred, and so that's why you see June as Gay Pride Month, like February is Black Pride, and March is Women's History Month, et cetera, et cetera. Every month has some sort of pride or history attached to it. So June is the month that we celebrate Gay Pride, and we embrace that. And it commemorates, as I said, the event. Although there are a lot of organizations that probably don't, they manage their pride celebrations during different times, given history and given weather conditions and all sorts of things. But June tends to be the month that it's celebrated. Another landmark event was the Employment Non-Discrimination Act, or ENDA. It was introduced, the Human Rights Campaign was very actively involved in introducing that legislation, and it never passed. It only passed the House. It never passed the Senate, I think, and so we couldn't get that passed. But it's passed again. We have another Employment Equal Rights Act, Equality Act, that's been introduced again. Again, passed by the House, and still waiting for the Senate to act on it. And we may get that passed soon enough in the next year or so. I know that it is a targeted issue from the Biden administration to get that passed. So it sort of would supplement, right, with more details, it would supplement the Title VII rulings. The 2015 Obergefell decision was really the thing that broke open the door and really made the way for Bostock, because the Supreme Court ruled in 2015 that same-sex couples and same-sex marriage was considered legal, yet people could still be fired from their jobs for being married to somebody of the same sex. And so, it was good to see that Title VII sort of closed that loop and said, not only, can people get married legally, so we've got the ruling from the Supreme Court that people could get married legally, we also had a problem with, people losing their jobs, and so that loop needed to be closed.